Good morning and welcome to the Justice Committee's first meeting of the new year, and I wish everyone a happy and healthy 2020. We have apologies from James Kelly and Jenny Gilruth, and I welcome Bill Kidd, who's attending as Jenny's substitute. Agenda item 1 is consideration of the Children's Scotland Bill. I refer members to paper 1, which is a note by the clerk, and paper 2 and 3, which are private papers. We have 2 evidence sessions this morning, and I welcome the witnesses for panel 1. Chloe Riddle, Policy Manager with Children First, Megan Farr, Policy Officer with Children and Young People's Commissioners Scotland, and Joanna Barrett, Policy and Public Affairs Manager with the NSPCC Scotland. Can I thank the witnesses for their written submission, which are always immensely helpful in advance of us taking formal evidence. And we now move straight to questions, starting with John Finney.
Thank you, Convener. Good morning, panel. Thank you for your contributions. I would like to talk about children's participation in the decision-making process, and in particular the proposal in section 1 of the bill to remove the presumption that of the 12+ presumption in relation to children's views. Could you comment on that, please?
Who'd like to start? Megan, it looks like you.
We're very pleased that that presumption has been removed, because we've definitely heard concerns and have heard of instances that have come through to us via our advice line where it has been misinterpreted as suggesting that children under the age of 12 aren't able to express their views and have them taken into account. But what we'd prefer to see than the current situation is that the existing presumption be replaced with a positive presumption that all children have the ability to express their views, and they should be given due weight in line with their age and maturity and their evolving capacities.
Thank you. Thank you very much for the opportunity to share our views this morning. In line with what Megan said, Children First view is that a rights-based approach should be taken to the provisions set out in the bill, and we're really supportive of removing the presumption. We are concerned, as Megan mentioned, that the complete removal of the presumption may inadvertently lead to less children being asked their views. I don't think it can be underestimated the impact that not listening to children can have on their lives. We've heard many instances of children who have been extremely distressed, whose mental health has deteriorated, who have felt forced into establishing and building and maintaining relationships with important people in their lives, but at a pace that they don't feel comfortable with, and that's actually detrimental to the relationship itself. So I think there's more consideration that we could do about how we could take a rights-based approach to removing this presumption and what we possibly replace it with, to make sure that even very young children are able to share their views with the court in a way that we understand isn't happening at the moment.
Yeah, thanks very much for allowing us to give evidence today. Most of what I'll say from the NSPCC's perspective and our expertise in working with children and families, it relates to very young children, 0 to 5. And for those children, the removal of this presumption is really important, because they are the children who are least expected and least asked about their opinion. So the removal of that presumption will help to clarify that children younger than 12 are capable of offering a view or experience. We also support a positive presumption to make that explicitly clear that all children should be entitled to and should be asked to give their view. The concern that we have is how that will be operationalised and who will be taking those views, because eliciting the views and experiences of very, very young children requires a specific skill set, and we need to make sure that those who are doing that are appropriately trained.
Thank you. I'll maybe pick up that with another question, but just before we move on to that, it's the view of the Family Law Association that the existing presumption is not preventing the views of children younger than 12 being taken on board. I take it you would all dissent from that, yeah?
We have numerous examples within our services of children who have not been asked their views or whose views haven't been taken into account, and the impact, and we know of the impact that that has. We know of children who have explicitly asked for their views to be taken into account, but that hasn't taken place. We also know of children who have been advised to instruct their own lawyers once they reach the age of 12 because they haven't been listened to up to that point. And I think that if all children's views were being taken into account in the way that you've just described, we wouldn't be seeing the amount of children within our services who don't feel listened to, who are reflecting that they are unhappy with their contact arrangements, that they're unsatisfactory, and that the relationships that they wish to build and that they wish to seek to establish are safe. At the moment, we're not hearing that in our services.
Wanted to come?
Yeah, regarding the existing provision, the existing presumption, as Chloe said, we've certainly also heard of instances where children's views haven't been into account and where that presumption has been misinterpreted. But notwithstanding that, in terms of the United Nations Convention on the Rights of the Child, the UN Committee on the Rights of the Child, in General Comment 12, makes it very clear that states should have a presumption that all children have the ability to form their own views and the right to express them, and that they should not have to prove that they have that capability, that the presumption should be that all children do. And going further, the Council of Europe issued guidelines on child-friendly justice, and they state children have the right to express their views and opinion on any issue or case which involves them or affects them. They should be able to do so regardless of their age, in a safe environment, respectful of their person. The existing presumption does go against this in that it does set an age, and there is an impact of having an age that results in the opposite presumption being possible and in some cases it happening. And that's why we support a presumption that every child has the ability to express their views and that those should be given due weight.
Yep. For the avoidance of doubt, I support that position too, as you may anticipate. I just wonder, in practice, what that would mean. What would substantially change, and is everything in place that would facilitate that? I mean, because it's all very well changing the legislation, but if there isn't, if you like, the infrastructure in place to support any proposed change, so what would that look like? Siobhan?
I think, going back to my earlier comment, what isn't in place at the minute is the kind of skill set that's needed specifically for very young children. You need individuals who are highly skilled and trained in child development to recognise what the inner world and the experience of a very young child is. I wouldn't say that's particularly prevalent within our child welfare reporters and our legal system. But also there's a cultural issue here. I think certainly we spoke to our childline counsellors in preparation for giving evidence to the bill, and they were very clear that family relationships and tensions within family relationships is one of the biggest issues that comes to childline, and repeatedly children talk about not being listened to, not being heard, but it amounts to an adult bias that children, particularly younger children, aren't able of forming or expressing a view. So not only do we have to have the framework in terms of legislation, the training in terms of the implementation of that, but we need to address what kind of biases might exist within our systems.
I think that, the committee will probably be aware that Children First submitted evidence on the financial memorandum together with Scottish Women's Aid, and one of the things that we were worried about is the level of resource that was allocated to this specific area. It's really important to note that the current removing the presumption actually doesn't require the courts to do anything different because they should already be asking the views of children. It's just a change to make sure that what's should already be happening happens. The positive presumption for us would really help to enforce that all children's views, including very young children's views, should be taken into account. But we believe that there needs to be a real strategic review about how this happens, because we know that there are significant barriers. There has been resource allocated to child welfare reporters, and I think there was something about the resource allocated to views where children can speak to the sheriff. But we know that there are a number of other ways that children might wish to give their views. And we've already spoken a little bit about the importance of a relationship with a skilled professional and the level of skills required, especially to share with the court the views of very young children who might not be verbal or who might wish to communicate in a different way. So I think Elaine Sutherland, when she spoke, Professor Sutherland spoke about being innovative and being imaginative and thinking a bit further about what the barriers are to currently allowing children to share their views and what that might look like in practice.
I think absolutely that's right. There does need to be more resourcing. One of the aspects that the UN committee raised in General Comment 12 is that it's important for children to be able to participate, that they understand their rights and that they're supported in expressing their views, and obviously that will be different depending on the age and maturity of the child and other aspects around their life. There's been some discussion about support workers, and I think that's an important thing that I'm pleased that the Scottish Government have committed to looking at further. That needs to be taken forward. And as Joanna says, there also needs to be work done to improve the capacity of the courts, including child welfare reporters, court welfare reporters, to seek the views of children. That's something that requires a very particular skill set. It's one of the reasons we're quite pleased to see that registration of court welfare reporters is proposed, because that will go some way to ensuring that there's a consistency around skills and training for that cohort of people. But there definitely needs to be more work done to improve the system's capacity. Children are able to express their views. We know that the system needs to be able to hear them in a way that is not harmful to children and that supports them properly.
Thank you very much indeed.
Rhona.
Thank you. Good morning, panel. I'd like to, just following on from John Finney's line of questioning, ask about your views on the decision to retain the 12-plus presumption for when a child's mature enough to instruct a solicitor, and whether you think there should be, there should be a wider review of age, the law on age capacity.
I think there's definitely issues around the Age of Legal Capacity Act, which wouldn't be a surprise. It's almost 30 years old. It is in some ways it's not particularly compatible with General Comment 12, and the presumption in that has the same issues. But I think that's a much broader issue that doesn't just relate to the type of hearings that we're hearing about here. It also extends into other areas, including medical capacity, and an aspect which is missing from the Age of Legal Capacity Act, which is education. So I think there's definitely a need for that to be looked at more broadly. I don't think that belongs here. There's a tiny mention of it in the current bill, and one of our recommendations is actually for that to be removed, because I think it has the potential to add confusion between the notion of legal capacity, the ability to instruct a solicitor, to understand a court action, instruct a solicitor to pursue one, versus the ability to express views, and those are very different concepts that develop separately and on very different timescales. So whilst I think,
so just to clarify what you're saying, so you would be in favour of not having that any presumption at all, so that if a child felt mature enough to instruct a solicitor, they could, or is that what you're saying?
That's not something we have a position on at present. There isn't work being done on that, but I think it's been acknowledged that there are issues around that at present. It's being operated differently, but it's not a topic for this bill. It's a much broader issue.
Yeah.
Okay. But the interesting thing on that is that it's the solicitor who has the obligation to assess capacity when their client is instructing them. Mm-hmm. And we know that children under the age of 12 are at times assessed as having that capacity. But as I say, it's not an issue for this bill, it's broader.
Chloe?
And we'd welcome a Scottish Government review of that.
Thank you.
And I think in our evidence, Children First have been clear that it does seem to be a little bit of an anomaly to leave in a presumption around, children needing to be 12 in order to instruct a solicitor. Our view, I think, would be that it would be better to remove the presumption and in line with the rest of the bill, enable children to be able to determine for themselves whether or not they feel that a solicitor is something that they would wish to engage with. We know that I think there was evidence that you heard from Professor Sutherland again, who talked about solicitors' roles in that, and I think it's important to look at whether or not solicitors have the ability to determine a child, whether a child is mature enough or has the evolving capacity to follow instruction, to instruct a solicitor and to know exactly what that looks like in practice. We have a 12-year-old in our services who is working very well with a solicitor who's represented and feels very empowered by it, and really feels that his voice is being heard much better by having a solicitor and representing himself.
Thank you. Joanna?
Yeah, it's not something we commented on extensively in our written evidence, but it does seem there's potential conflict with removing the presumption to give views, although, as Megan says, they're very different issues. 12 seems quite an arbitrary age, especially when our knowledge of child development and how child behave and how children mature has grown since the Act was passed. So, yeah, I think there should be some reconsideration, but perhaps in a separate forum.
Okay.
Just like to add, if there is further consideration of it, I think we should approach it from a child's rights point of view in terms of incorporation of UNCRC. My assumption would be that something that was child's rights compliant in that respect would look at how children could be further empowered and supported.
Okay, thank you. If I could just move on to ask you whether you agree with the findings of Dr McFarlane's research report that the bill should set out a non-exhaustive list of the different ways children's views can be given to the court, and also to give a child a say in which method is used in each individual case. And I know Chloe touched on this a wee bit in an earlier answer, so would you like to expand?
I think that the primary thing for us is that we know that children want to give their views in a variety of different ways. We would be concerned that a prescriptive list would limit the way that they give their views, particularly as technologies evolve and children begin to share their views in a variety of different ways that perhaps haven't even been invented yet. But for us, I think the review that I mentioned is really important about looking at what the blocks and the barriers are to the way that children give views at the moment, and really to ask them. I think one of the primary things that we need to do is to check with children what they like to do and how they give their views. I know that there is a provision in the bill that says that views should be given in a manner suitable to the child, but it doesn't talk about asking the child what that manner is. We know from our services that children like to draw pictures, that they like to make videos, that they like to speak to the sheriff directly. As I mentioned, one of the children we know has their own lawyer. We know that there is an extremely valuable role for the child welfare reporter, alongside the importance of adequate training for these really skilled professionals. So I think to answer the question, for us, we'd need to look at a bit more of the detail about what a list would look like. But I think we'd be quite cautious about having something that's too prescriptive, that doesn't allow for children to express the way that they want to share their views, or not want to as well. We need to allow for some flexibility for children to say that they don't want to express their views where that's not appropriate or safe.
Can I just say at that point, I was really struck by your comment in your submission which said children are not robots. We cannot expect them to be passive bystanders going along with the decisions made by adults in a system designed for adults without examining the impact. I thought that was a really powerful way of putting it. Yes, Megan.
I think that on the latter issue around whether children's views should be sought, yes, part of the children's participation should be understanding how they wish to participate. So that should be taken into account by the courts. It may be that, and it's the same with all situations where you take a child's views, that you're not able to do what they want exactly, but that should definitely be something that's taken into account and given due weight. In terms of a list of examples of ways or something like that, it doesn't feel like something that belongs in primary legislation. It's possibly something, there's a role for guidance, and that would give it the opportunity to evolve. But I don't think I think the risk of a list is that the list can become interpreted as being prescriptive, rather than something which will develop over time. The court's abilities to do this will develop over time as practice evolves. and that flexibility should always be there, that at some points for some children there might need to be some really quite creative approaches taken and different expertise brought in. So it doesn't feel something that's appropriate for legislation. It's certainly something the Scottish Government should look at including in guidance, but over-prescription isn't likely to be useful for children.
Thank you. Joanna?
Yeah, very much what Chloe and Megan have said. A prescriptive list, I don't think would offer the flexibility we need, but I do think there needs to be some kind of minimum floor or standards or, of what children could expect and what sheriffs might be able to offer, or court welfare reporters and others. And again, this is not just a question of how, but who, and that's important consideration in this as well.
Okay. Thank you. Oh, sorry, Chloe.
Sorry,
Chloe, want to come back?
Oh, sorry,
Do
do you want to come back, Chloe?
Just a final point. I just wanted to remind the committee, of course, of the upcoming incorporation of the UNCRC, the bill that we'll hopefully see this year, and if we are looking at the current bill in terms of making sure that we're compatible with the CRC, if we introduce the entitlements that we've spoken about in our submissions around best interests, around children's voices, I don't think there would be a need for a prescriptive list, because there would be the flexibility built in and the safeguards in terms of children's best interests and voices that would be on the face of the bill to enable children to be able to decide for themselves what the best way would be to share their views.
Thank you.
Bill.
Thanks very much. It's extremely interesting the way that you've developed the discussion in terms of children's interest, and it coming in at a different area of the bill. Section 15 creates a new duty to explain court decisions to children, but there will be variations subject to various exceptions. A child might not be able to understand and really sort of take in the court decision, or it might cause distress or something to the child under certain circumstances. Have you got a view on how the new duty to explain the court decisions to children will develop? Who would do it and how they would present it?
Arguments around about this are very analogous to the arguments around about the voice of the child, that who does it is really important, and they need to have the right skills, and it will be on a case-by-case basis. It's reliant on the adult knowing how to communicate well with a child and deliver the messages that they have to deliver in an appropriate and sensitive way. But I think round about the voice of the child and round about explanation of decisions to children, I think we maybe need to reframe this. This is not necessarily about the capacity of the child to give views or to understand. This is a lot of the times about the capacity of the adult to listen and to explain. So we maybe need to think about it a wee bit differently.
Right, okay, thank you. Anyone?
Yeah, I absolutely agree with that around when we need to be looking at the capacity of the adults and the system to work with children, and that there's a lot to be done in that. We're really pleased to see this included on the bill. One of the things that we hear is that children don't always understand. It's often left to one of the parents to explain, and that can put that relationship in a very difficult position, particularly if the child is not happy with what the decision. So we're very pleased to see it. It is, again, it's going to be something where there needs to be some work done to build the capacity of the courts to actually deliver this. Children will often need some support in understanding that, and particularly in coming to terms if a decision hasn't been in line with the views that they expressed. We hope that this happening may help with understanding of why, for example, contact orders aren't always followed, because it will ensure the child hears in a neutral way exactly why the court has made its decisions. So it's a very it's a good step of progress, but we do really strongly feel that again, this is going to need more research to understand how to best do it. The court is going to have to develop its capacity to deliver its obligations. But again, going back to General Comment 12, which I spoke about earlier, it is an important part of the participation process that the child hears what the outcome of giving their views was, to what extent they were taken into account, and if they weren't, why. So it's very much a welcome piece, but again, it's going to need work to develop how that's delivered. But it is a child's right, so delivering this isn't optional.
Sorry, Chloe, would you think it's a trust and confidence issue the child would have in the person who was there to explain it to them. So they would have to follow them through from an early stage and not just come in at the end, you know. So.
I think you're drawing on the wider issues around support workers as well, which we, as Megan mentioned, Children First are very, very pleased that the government have started, will be looking at the issue of support workers. But we know from our services that having a trusted professional, somebody or a trusted skilled person to build a relationship with a child makes a significant difference, particularly in terms of their recovery from what they might have experienced, particularly if domestic abuse has been involved. In terms of feeding decisions back to children, this is something we've really welcomed in the bill, but I think it does need some more consideration. We know that at the moment this isn't happening in a way that's very consistent. It's not happening in a way that's satisfactory to children, and often children are feeling quite lost and confused about what's happening, and particularly when there's an ongoing court process over a number of years. We would really welcome consideration about how a court can keep children up to date regularly, but the decisions about how this should happen and who should do it need, first of all, some resource, because that, as I think we'll probably look at what we said in our financial memorandum, look at what we said in the response to the financial memorandum would be helpful, because there has been some resource allocated, but putting all of this on a child welfare reporter is quite a significant role for them. And I wonder if there are other ways that decisions can be explained to a child, and what their views would be about how they would want. Some children might wish to be informed every step of the way, other children might not. I think it's really important to remember that this isn't always a kind of a one-off hearing and then that's it for a month or a year. It could be a number of different decisions being made over a number of years that might change frequently. So it's really down to the child and what the child wants, and the ability of the court to build that relationship with the child and find out what would work for them. I believe that in Power Up, Power Down, the research that Children's Commissioner and Scottish Women's Aid did, they talked about integrating a system of feeding back decisions and ensuring children are involved in all parts of the process. So it's something that I think requires further consideration about how it will work in practice.
Thank you. Oh, sorry, Megan. Yeah.
I was just going to add, one of the things we are concerned about in this, in the bill as currently written, is that there is discretion on the court not to comply where it's not in the best interests of a child. We'd be really concerned if that was used in anything other than exceptionally rare circumstances. And would welcome it actually if it was monitored when that decision was taken, to make sure that it wasn't there wasn't an excessive degree of caution
Makes sense, yeah.
in that respect.
Thank you very much.
Okay. I think that's probably two areas that you've covered there that would be worth looking at stage 2, where we really need a lot more information, especially as I see the judiciary have real concerns about how they would deliver this duty. Right, Liam MacArthur.
Thanks very much. Good morning. I want to turn to the issue of confidentiality of information. Obviously, it's something I know that Children First, amongst others, have expressed some concerns about. The Scottish Government consulted on a legislative provision back in 2018 that would say a court in deciding whether confidential information should be made available to a litigant asking for it, that this should only be done so where it's deemed to be in the best interest of the child and after the child's views have been taken into consideration. We have, though, heard some concerns from Professor Sutherland at the session just before before Christmas about how this might come into conflict with ECHR rights that relate to the adult concern. And I just wonder whether the panel might be able to talk us through where their concerns lie and how we might be able to navigate that situation where there's potentially a conflict between the interests of and rights of adults and the best interests and rights of children.
In terms of the right to a fair trial, which I think is what Professor Sutherland was referring to, there is a balance to be struck between that and the right to privacy of anyone, including the child, but not just the child, anyone else who is discussed in a service provider's report or notes or something like that. We're concerned about any cases where entire case notes are opened in court. The child's right to privacy is very important, and the child's best interests should also be a factor. And in some instances, there's actually concerns that the child's welfare may be at risk if an entire set of case notes is made available to all the parties. It's a balance that needs to be struck, but we're concerned. We would be concerned if there were further instances, and I know there have been examples previously where that happened. Where information is sought, it should be really tightly specified, not a request for an entire file.
So in a sense, it's about the relevance,
proportionality
and
proportionality and relevance. Yeah.
Okay. So,
I think as the committee will be aware that this is something that Children First have been really keen to address for a number of years now. Our view is that primary legislation is needed in order to ensure that the court system, in order to make sure that this bill is compliant with the CRC. But for us, it stems from a real case. It's not a hypothetical situation. It stems from a case for us where I don't think it's helpful to go into the exact details of the particular case, but where children's confidential information that were held by a third sector organisation, by Children First, were revealed to the court in their entirety. And our concern is that the rules that were in place did not prevent that from happening, and that in the future, and indeed in this case, there is the potential for the files, the information that were released, the personal, private information that was held by ourselves, that were released to the court, but also to a potential perpetrator. So we are potentially in a situation where the private, personal information about abuse, potentially, or about children's thoughts and feelings and views could be shared with a perpetrator of that abuse. Our concern here is that we're absolutely not seeking a kind of a blanket prohibition or inadmissibility of information being sought by the courts. We know that the third sector, that statutory organisations often hold really important information that we will need to share with the courts to help them make their decisions. But what we're talking about is ensuring that there are tests and balances to make sure that it's proportionate, and also that children are involved in this decision where it's appropriate and where it's safe. I think that we've heard, the committee's already heard of instances where children have shared information willingly, but haven't been aware of where that information has gone and what's happened to it. Certainly for us, it's a concern that we are not able to tell the children that are working in our domestic abuse services, for example, that the information that they share that's not relevant to a particular court decision will not be, we cannot guarantee that it will not be shared. We're worried that that will have a detrimental impact on the service that we provide, that it will limit our ability to have full and frank conversations and to help children to recover. So it's a really significant, really important issue that we think is really important to raise within the bill. We'd really welcome an amendment or consideration of an amendment at stage 2. And finally, just a short note on the court rules, because I know that there are court rules in existence already, and the government have already talked about further court rules in this area. The advice that we've had from our solicitors who worked with us on the initial case is that the practice notes don't obviously hold the same level of protection as primary legislation, and there's a greater risk that a court practice note wouldn't be followed. We know that some respondents to the initial consultation argued that the rules in the Sheriff Court and the Court of Session address the concerns, but we believe that there's a clear framework in primary legislation would really avoid any doubt, would put children's best interests and their voices right at the centre of any decisions around this, which is in line with the original intentions of the bill.
That's helpful. I mean, I suppose it's entirely understandable that a child of any age is likely to be more relaxed and willing to be forthcoming in terms of the views, particularly around more sensitive issues. possibly relating to abuse. But at the same time, it is not hard to imagine that some of that sensitive detail around abuse is going to be entirely relevant and proportionate to a particular case. How is that managed with the child, so that I suppose their expectations are managed through the process, that their voice will be heard, but some of this information will have to be revealed to the court at some point?
No service is able to guarantee complete confidentiality to a child or family. There are already existing laws around child protection, duties that we have to share information where it's going to keep children safe. But for us, we are not talking, as I said, about not revealing any information at all, but it's about making sure that what's revealed or shared with the court is proportionate. So where it's relevant, absolutely information should be shared, case files should be shared, the voices of support workers and so on should be shared with the court. In fact, we very much welcome the inclusion of support workers' voices and views within the court so that they can share their experience of working with families. What we're talking about here is an entire case file in its entirety that contains information that's not relevant and not necessarily that a service provider would make those decisions, but perhaps the court would make those decisions. But then they would not. The information that's deemed not relevant is then not shared with other people who it's not necessary for it to be shared with. The example that we had of the file that was shared contained a detail of dreams, for example, quite detailed information about things that were happening at school, things that we didn't consider to be relevant to the particular case. And I think it's about being proportionate. Any amendment that we would encourage, I think, would include something around making sure that the welfare of the child is paramount, the safety of the child is the paramount consideration, and that children's views are sought. So we're not even encouraging an amendment that would say that children have the final say on what happens to their information, but rather that they are informed about what happens, that they are part of the decision-making process, and that if the decision is made to share their information, that they are informed of that and that they know what will happen to it after it's been shared as well. And we know that we do hold information that's really relevant, that's really important, but if we are operating on a basis that any information that we hold, that any case files, that any documents that we hold might possibly be shared blanketly with the, on a kind of without any checks and balances, it's really detrimental to the way that our services operate.
Okay. And so you think that amendment could be framed in such a way as to be ECHR compliant as well as meeting those?
I think so. And I think we could make a really strong argument that at the moment, instances such as that are not compliant with either the EHRC or the UNCRC.
Okay. Thank you. Thank you.
Sorry.
1 and 12 and explored that with you. Section 1 seems to repeat what the Family Law Scotland Act 2006 already had in terms of two factors that the courts must consider: the prospect of parental cooperation and need to protect a child from abuse and risk. And then Section 12 adds to that in terms of court order and the effect that might have on the involvement of a child's parent and on the child's important relationship with other people. Could you comment on these provisions and, just what you think about having almost a list here? And I noticed, I think, was it Megan, the Children's Commissioner in particular, said that he was supportive of the extended family, although he did make a distinction about it being a statutory factor and should rely more on the perspective of the child.
Our view is that presumptions, where they exist, should always be centred on the child rather than on adults. The one exception is around siblings, where obviously that's more than one child, and their best interests need to be balanced with each other. I think this has arisen from some discussions around people like grandparents, but actually children have a range of adults who are important to them, and they may or may not be related to them biologically. So our view is that although it's a child's right to have continued contact with their extended family if that's safe and in their best interests. We didn't go into great detail on this particular section, but it was that any presumption should be centred around the child and that right and around their extended family, rather than focusing on any particular specific adults in their lives. If you start talking about grandparents, you also have aunts and uncles, godparents, but also other adults who've played a significant part in the child's life. By focusing on the child, we keep that as the main focus, and it doesn't become a situation in which adults have rights to the child. The focus should be around child having rights to those relationships.
So could there almost be a danger of a checklist, sort of tick that, as opposed to looking at the individual case and whether that was appropriate in that individual case?
Indeed, I think that's the risk with lists generally, and we've already spoken about lists in another context, is that whilst a list can help people think about specific factors, it can also serve as a way of limiting what gets considered to what's on the list.
Okay. Chloe, or
we don't support a presumption de facto or otherwise of maintenance of relationships with anyone. It has to be about what's in the best interest of each individual child. The relationships round about each and every child will be different and will be beneficial or otherwise in each individual case. So yes, of course, contact with extended family is important, but in terms of primary legislation, we wouldn't support any particular presumption.
Okay, Chloe?
I think our views at Children First are very similar. The primary concern for the court must be the best interests of the children. I know that others such as Clan Child Law have done a lot of work around sibling contact, and I think I would usually defer to their expertise on this particular issue.
So do the panel think the bill's more or less got it right in terms of the provisions, or does it need to be clarified in any way?
In terms of sibling contact, we really support the intention to make sure, obviously sibling relationships are massively important to us all where we have them, but it's a real question of how this is going to work in practice. You might have a situation where you have two children and two competing best interests, where contact with a child, with a sibling, might be in one child's best interest, but not in the other. And how do you resolve that situation? How do you manage that situation? Again, it has to be a case-by-case basis, an assessment of the best interests of each and every child. And again, who's going to make that assessment of what's in the best interests of siblings? So I think, ultimately, yes, support the general principle of that provision, but have concerns about how it will be implemented.
Chloe?
It goes back to what we've been discussing more broadly around training and around support for listening to children's views, for making sure that there's enough time to establish and build relationships so that children feel comfortable to share what their thoughts are about what they think about the relationships with the important people in their lives, regardless of who they are. There's a lot of different considerations to be taken into account, and I think that the important thing is to ensure real resource for the training so that children are able to fully and clearly express their views in a way that that reflects the reality of the situation for them, and in a way that means that they don't fear any kind of repercussions for what they might be saying, so that there's a real trusted relationship and that they can share their views, and so that decisions can be made in their best interests.
Okay, so is it fair to say when Shared Parenting Scotland sees the bill as a missed opportunity to give sharers more guidance, then if they wanted comprehensive checking covering the issues, then that would be too prescriptive. But the way the bill is worded, it doesn't stop any of these relevant issues being looked at if it's suitable for the individual child in that case.
Yeah, I think we've said something regarding the entirety of 11ZA and ZB in that we feel, and we've discussed this already with the Scottish Government, that it would benefit from being reframed from a child's rights perspective. And this is one area where that's specifically the case. I think extending a checklist would be overly prescriptive. I don't think it's a missed opportunity in that respect. I think the missed opportunity is probably in making it as UNCRC compliant as possible, and I think that would really strengthen this bill.
What would that look like if you were seeking to amend this?
Without specific examples to hand, I'm going to, rather than scrabble underneath, borrow Chloe's version of the bill. In terms of the...
11Z8.
It's here. Thankfully, it opened at the right day. It's looking at framing it in terms of the child's rights to be protected from abuse rather than need to protect the child from abuse. So framing it in that sort of rights language, the right of the child to be cared for. In terms of 11ZB, talking about children's rights and to give their views. We'd also say the same thing should be the case in terms of their right to maintain relationships with members of their family rather than looking at it in terms of individual members of their family.
Yeah, so it's just turning it around. So again,
so the focus is on the child.
Absolutely at the heart of this. That's helpful.
I think obviously Scottish Women's Aid and Assist will be giving evidence after this session, but it's really important to remind the committee that we must also view any changes through a lens of domestic abuse. If we get it right for those most vulnerable people, then we will get it right for everybody. And there are significant factors to take into account around safety and around children's best interests when domestic abuse is involved, and that should be taken into account when the bill is being amended.
And whilst domestic abuse are a minority of families, and that's a good thing, they're not the minority of cases that reach the court.
Mm-hmm. Will there be cases where a parenting order, there's no obvious there's no domestic abuse, but there is a dispute about parenting orders then? So is that covered sufficiently, do you think, the provisions cover these situations?
Yes, I mean, my understanding is it's roughly half of cases that reach court. That's fairly consistent research finding across jurisdictions and over time. Yes, I think that those are the case. If it's centred on the child's right, Article 18 of the UNCRC has a principle around the involvement of both parents in a child's upbringing. Now that's the caveats on that are the best interests and the welfare of the child, but I think that is adequately covered by the present bill.
Okay, thank you. Thanks, Shona.
Good morning. I have two questions. The first is on the child welfare reporters and curators ad litem. Sections 8 and 13 of the bill propose regulation of both. We know that you're supportive of this principle, but it would be helpful if you could tell us what you think are the key features of any regulatory regime that should be brought in. So, for example, things like qualifications, training requirements, and any concerns that you might have about how any regime would operate in practice. And I've got another question, but deal with that first.
Yeah, we support the regulation of court welfare reporters. The policy memorandum says that 90% of court welfare reporters at the minute are lawyers. And we pose a question whether that skill set is conducive to best practice in engaging with children and fulfilling UNCRC obligations. It's not that lawyers can't engage with children, but other professional disciplines are more skilled, arguably, in that. We support moves to widen the professionalism of court welfare reporters, so to encourage psychologists, social workers and others to be court welfare reporters. But we are concerned, and certainly our experience within the children's hearing system is that there are professional biases within our legal system that lawyers are deemed to present arguments in a better or more compelling way, and that social workers and others feel less confident in legal forums. So we need to consider what's more important. Is it the court welfare reporter's skill set so that they can fit into our existing legal system, or is it their ability to work effectively with children? We would argue that it's the latter. So any regulation has to contain minimum standards in terms of training, and that ultimately has to be a fundamental understanding of child development and how to engage and relate to children.
Okay.
We also support the proposals for regulation, and the fact, as Joanna says, that the legislation's been developed in a way that provides with flexibility in terms of who. It's not prescriptive as to who a child welfare reporter is in terms of specific qualifications. We would like to see the development of training requirements and qualification requirements that recognise areas that are really important: human rights, particularly children's rights. Child development is a really important thing for child welfare reporters to have an understanding of. Seeking the views of children and how to support them when they're expressing their views, particularly if they choose to do so in person. The legislation is framed in such a way that there is flexibility as to what professional qualifications an individual might have, and I think that's a good thing. I think this is an area that's going to evolve over time, and that we're not likely to see a very quick change in who a court welfare reporter is, but it's good that that flexibility is built into the legislation.
As the committee might be aware, Children First currently operate the Safeguarders panel for the children's hearings. Our learning from that is that it has been a really important process. It's taken a lot of time for us to establish procedures and processes to streamline practice, but it has been worthwhile. And there's a lot of lessons that we can take from that in terms of the operationalisation, the administration of the panel. In terms of what's being tried to be achieved, we've heard many times from the children and the families in our services of very good experiences of working with child welfare reporters, really good examples of children feeling listened to and heard, and the reports being very high quality. But on the flip side, we've also heard examples of children feeling quite traumatised by the experience of repeated questions, of 3 or 4 occasions where a different child welfare reporter has gone back to the same child over a number of years. So I think that the intention behind this part of the bill is really important, and we really strongly support the findings of the research and the work that the Scottish Government's done on this. It's such a vital role that the child welfare reporter can play in the civil court process. It can often be the deciding factor. The report can often be the deciding factor between what contact arrangements look like. So therefore, we need to make sure that we're really investing in this role. And that there's a significant amount of training that's undertaken if contact arrangements are unsafe for children, because there's been a child welfare report that hasn't understood the dynamics of a child welfare report that hasn't understood the dynamics of domestic abuse or the realities of what family life is like. Then it can be really it can significantly impact on a child. We don't want to see a postcode lottery of provisions, so it's really important to make sure that this training is streamlined, and it also includes training not just on domestic abuse but on trauma, on attachment, on, as Joanna was talking about, on child development and how children communicate in ways that aren't necessarily verbal communication. Our experience with the Safeguarders panel is that putting in place the safeguards can be really complex. It does require a significant amount of investment in time, but that there are advantages in terms of advancing children's rights. If we get these reports right, where it's safe and appropriate for a child welfare reporter to be in place, we can make sure that contact arrangements are more stable, that children, families, women are much happier with the arrangements that are in place, and it can prevent us from going back to court repeatedly when unsatisfactory arrangements are in place.
We agree that could be the major benefit from it, and very much welcome Scottish Government's commitment around funding of court welfare reporters. That it's a situation where effectively discrimination existed, in that if one of the parents was in a position financially to pay for a court welfare reporter, child got one. If one of the parents was legally aided, child had one. But for those children who fell in between those two groups, their access to justice was impeded by financial considerations. So the commitments around funding are very, very welcome from that point of view.
Okay, thank you for that. My second question relates to those contact arrangements and regarding specifically the regulation of child contact centres, and whether the panel believes that is a desirable thing, and if so, what the key features of that regulatory regime should be. What type of regulation do you think would improve safety while ensuring that people can still access a centre local to them? I know that it's not everyone will use a contact centre, but I think it's an important part of this going forward.
We've welcomed this as well. It's important we know that Relationship Scotland also welcome it. They operate the vast majority of contact centres in Scotland. I think long term, this is an area that potentially needs to be developed about what is the most appropriate situation for children. One of the things we're hoping will result from regulation is it will improve understanding of what child contact centres are and why they're there. We've certainly heard of instances through over the years where they've been used inappropriately. In line with regulation of welfare reporters, we think there's a real opportunity to raise standards in terms of training, of requirements for staff, in terms of ensuring that facilities are safe. But we absolutely recognise that there are quite significant concerns about resourcing. They are not a service that's funded by government. And are often funded by the parties, and we know that some of them are have particular resourcing issues. So we would be disappointed if regulation was so stringent as to restrict the number of contact centres. But we think that believe the government's current proposal is for the Care Inspectorate to undertake inspection. We think that they probably have the ability to take a proportionate approach to an inspection regime to ensure that those standards are improved. Training needs to cover similar issues to welfare reporters, including domestic abuse, because again, disproportionately those are the cases that reach court. Even more disproportionately, those are the cases that end up with contact centre usage, to ensure that that staff there have that understanding in terms of their role in keeping the child and the non-abusing parent safe. But we also are concerned that there are some instances where contact centres are used, or contact is ordered at a contact centre where there is very little potential for that contact to progress to unsupported or unsupervised contact. We're not convinced that that's always in the best interest of the child, where at that point in time it doesn't seem that the parent having contact will progress to a point where it can be safe for them to have their child with a contact centre.
Okay. I would just endorse that. I don't have much to add to that.
I think the starting point when we talk about contact arrangements needs to be the right that children have to safe and positive relationships. It's not always appropriate, and indeed it's not always safe for a child to be at a contact centre, and I think we must be really clear that when we're making these decisions, that decisions have to be made in the best interests of the child, and we need to consider what arrangements are safe for them. In our view, contact centres can play an important role in facilitating safe contact arrangements, and there's a lot of potential for them to be part of a rights-based approach to civil justice. There's a lot of scope for contact centres to develop into welcoming places where children and families want to go, but this does require resource. We've mentioned this already in our response to the financial memorandum, so I won't go over in too much detail, but we have talked about provisions, for example, those children living on island or rural communities, and it's really important to reflect, as Megan mentioned, the importance of training, and we know that contact arrangements are often used to continue to perpetuate domestic abuse. And it's vitally important that that isn't allowed to continue, and that the staff or the professionals who are supervising the contact are alert to that, and the courts are alert to the way that that can happen. For us, the training must also include child development, communication and trauma. We know from Relationship Scotland's submission to this consultation that there's been an increase in recent years in the complexity of issues faced by families using contact centres, including mental health issues, addiction issues. So we'd be really clear, keen to see what the practical considerations are for children who whose parents are experiencing some of these challenges, and what contact centre staff should do if they're concerned about what happens in a contact centre, and what they're seeing, who they should report to, what happens when contact arrangements aren't suitable anymore, and how that can be remedied, and children's views about how it's happening. So the broad answer is that we think that it's important to regulate these centres, that training is really vital, but there's a lot of discussions to be had to make sure that this is safe and appropriate and in a child's best interests.
It would be helpful maybe as a follow-up. You referred, I think it was yourself, Megan, referred earlier on to examples of good practice, but also examples of not so good practice. So without, I mean, if that could be presented perhaps in a way as a follow-up letter in a way that you think is appropriate, it would be helpful, I think, for us to get a little bit more detail on that.
Yeah. Rona, can you finished? Sorry, is Shona finished?
Yes.
Rona,
yeah, thank you. Just a short supplementary. Just on that, we know that there has been concern on children sometimes being ordered to have contact with a parent, and they've said that they don't want it, whether it's domestic abuse related or not. So I'm just wondering how confident you are that sheriffs and people taking the decisions, whether they will take into account the views of the child, and that's obviously paramount. We've talked about giving children a greater voice, but do you think the judicial system is ready to accept that and actually, take that into account and make the decision based on that?
I think there's some very good practice out there, but I think there are probably sheriffs who could benefit from some further training on that. I think it's one of the benefits of the bill, and it's one of the reasons why we're really pleased to see the improvements that this bill represents around seeking a child's views. In particular, I think there needs to be a better understanding quite broadly around the child's evolving capacities, in terms of the work that was done by Dr. Jerison Lansdowne around that some years ago for UNICEF. That's a particularly useful resource around that. There's undoubtedly a need for training if the examples that we hear coming through, particularly telling examples that we get, for example, is where there's a family with several children and contact is ordered when the children are under 12, but as the children reach 12, they are suddenly heard and contact is no longer ordered. However, their younger sibling, who is saying exactly the same things and is perhaps 10, the contact order remains in place. The continuing number of cases that I hear about that, we hear through our own line, we also hear from colleagues in other organisations that they're dealing with similar cases, suggests that, yeah, there is definitely a need for better training and awareness out there. And I think this legislation hopefully will be a catalyst for that happening.
I think this is another area where the needs and behaviours of very young children can be overlooked in a very detrimental way to children's welfare. We work with many children who are in contact situations which are very distressing to that child, very young child who can't articulate that it's distressing, but they come home and their behaviour changes and their toileting changes and their sleep changes. So there are very demonstrable behavioural signs that contact is not in that child's best interest. But I don't know the extent to which that feeds into contact decisions. The other thing I would highlight is the interplay between our various legal systems. I don't think that happens enough. So we have instances where, contact's been decided in the children's hearing system, but there's also a civil action or even a criminal action against an individual for domestic abuse or sexual offence or something else. And we have had instances where someone is accused of a Schedule 1 offence, but contact is continued via the children's hearing system. There needs to be much more integration between our legal systems, particularly in terms of contact, to make sure that it all makes sense and that children are kept safe.
There needs to be a better awareness that whilst children have a right to grow up in an environment of where they have contact with both parents, that's only if it's safe and in their best interest to do so, and there are absolutely cases where it's not.
Just to add to that, one of the most important provisions in the bill for the families that we support is around investigation into non-compliance, and I think that has such an important role in understanding why some of these arrangements haven't been complied with. It's
covering that separately, so if we could hold your fire on that just now, we'll go into
it. Was just to say that in addition to that, I think the thing missing that we've all talked about is around the ability for children to feed back when a decision has been made, so that while there is the measure for an investigation into non-compliance, there isn't the provision for discussions about what a child thinks about the decisions made and their views, or even a chance to review contact arrangements after a particular time.
I think the other thing that's often missing is an understanding of the impact on the child when one parent is in a position of having to force them to attend contact. That puts both that parent, but particularly the child, in a really difficult position where they absolutely do not wish to attend contact, but the court order means that effectively the resident parent has forced them to go to that contact. It ends up damaging that relationship as well.
Thank you. Thank you. Fulton.
Thanks, Convener, and good morning, panel. Thanks for a very informative session so far. I wanted to get your views on the sections 4 to 6 of the bill for vulnerable witnesses, and obviously for cases that do go to proof. I wanted to hear your views on those provisions of the bill, and in the interest of time, I would just follow up with a further question to ask if you think that these should also be extended to children's hearing themselves.
We support the measures in the bill and absolutely think they should be extended to the children's hearing system, and I think that's fundamentally the point I would like to make here, is for the committee to have in your mind is not perhaps for this bill in terms of amendment, but in the wider consideration of this bill, how do our legal systems interact? Because in our criminal system it's become accepted to say that it's not good enough and that how we treat vulnerable witnesses in our criminal system has to fundamentally change, and we're looking at the Barnhouse or Child House model and we're trying to get children out of the criminal system. Here in this bill, in the civil system, we're trying to introduce measures for children and other vulnerable witnesses to perhaps remove them from attending fora directly, but giving their views in a way that's safe. In our children's hearing system, there is a compulsion for children to attend. And I read with interest Children Hearing Scotland's submission, where they say that perpetrators, victims, child victims, adult victims and perpetrators of abuse are entitled to and must attend hearings. So we have a complete lack of synergy in what our expectations and what our protections are for in our interest children in our various legal systems. So in the criminal system we're trying to get them out of the system altogether. In our hearing system we're making them be in a room with people who arguably have harmed them. And our experience of children's hearing systems is that very young children are being forced to attend hearings in a way that is detrimental to their welfare. So we absolutely support this, but we think that we also need to think about what are the protections and our expectations for children in the children's hearing system.
So on that point, the Scottish Children's Reporters Administration have said that they think that evidence in family cases should be treated actually the same way as in criminal cases, e.g. taken in advance where that's practical. And that would mean that sections 4 to 6 would not be required for children. What do you think of the Children's Reporters' views on that, based on what you've said there? And perhaps when other panel members come in, if you could reflect on that as well.
I think I'm right in saying that the Scottish Children's Reporters Administration are talking about proceedings in front of the sheriff that relate to hearings.
Yes.
Absolutely, there have to be protections. We're talking about extremely vulnerable children if they're at the children's hearing system. But I suppose what I'm talking about goes beyond that, about individual hearings within our hearing system. We're making children, very young children, we've got experience of 18-month-old, 2-year-old children being forced to sit across from someone who has cause them harm. And our practitioners are regularly distressed by attending regular hearings where children are distressed and showing real attachment behaviours. So absolutely support what's in this bill. I would support what's Grassy in terms of extension, but I think we also need to look at our hearing system. I think we uphold our children's hearing system rightly. The Kilbrandon principles are to be admired and advocated, but I think its operationalisation falls short of what our expectations are, and I think we champion the children's hearing system arguably to an extent where we're quite complacent, and I just think that we do need to think about protections in the hearing system and our civil system and our criminal system and what's the coherence there.
Article 2 of the UNCRC states that states shall respect and ensure the rights set forth in the Prison Convention to each child within their jurisdiction without discrimination of any kind. That's the non-discrimination principle. A child is a child is a child. They are just as much a child in the children's hearing system as they are in the criminal courts, and they should be afforded the same protections across all forums.
I agree completely with my colleagues that we can't be having a situation where we are trying to establish a gold standard model of a child's house in the criminal courts and a system where children are feeling like their rights are being violated in the civil courts and in the children's hearings. In terms of the provisions in this bill, my understanding is that very rarely children are going to be attending the civil courts, but the provisions are really important for women. I think for victims of domestic abuse. For the purposes of this bill, a lot of it comes down to implementation. So the special measures are really important, but the special measures will only work if there is real consideration of the whole experience and what it's like for a victim of domestic abuse. For example, if a victim of domestic abuse is walking through the court doors at the same time as a potential perpetrator and then sitting for 3 hours in a waiting room where he or she may walk past and, they may be using the same space and then going into a court where there's a curtain or a screen between them, it doesn't make, it's a fairly distressing experience. So we must make sure that the special measures are implemented in a way that makes sense completely for the whole experience. It's really important that perpetrators of domestic abuse are not able to continue to perpetrate abuse through the courts. So we really welcome these provisions, but it is important. I'm imagining that Scottish Women's Aid will come and Assist will come later on this morning and talk about how a victim will be determined, for example, and links with criminal court proceedings, and those are really important considerations when looking at the section on vulnerable witnesses. We do really welcome the provisions about making sure that somebody isn't able to cross-examine a victim or to question, but I think it's as my colleagues have been saying, it's about making sure that we're streamlining the process across the different proceedings, bearing in mind that we're talking about the same children a lot of the time. Many children who are going through often the criminal courts, the civil courts, and the hearings at the same time, experiencing 3 different proceedings.
I think it's important to remember that although the system experiences that as 3 different systems, 3 different sets of proceedings, that's not how children experience their interaction with the court system.
Yeah, thanks for that. And following on from your last point there, Chloe, I was going to ask about Section 7, if the bill, and for the panel's views on that. And this would of course allow the Sheriff Court for the first time to order use of special measures in court hearings where formal evidence has not been taken. I know that Children First with Women's Aid have been critical of this aspect of the bill, and I know that Assist have also referred to it, but I wonder if it's worth the panel putting on the record the views on Section 7.
Sorry, on the section on
It's vulnerable.
In child welfare hearings specifically, Section 7.
Yes. I don't think I have any further comments in the comments that if I'm interpreting you correctly, the response that we made is in line with what I think I've just mentioned about making sure that the implementation the implementation is well thought out, so it's not just about the actual being in court, but the whole court building and the whole process and procedure. And I think, as I mentioned, I think there are some concerns about how a victim would be identified, particularly if there's no criminal proceedings, and how the special measures would be applied. And I know that we wrote in our submission about ensuring that any children, that the measures apply to any children. Though our understanding is that very rarely there would be a child actually physically present in the court that would require the special measures. Though obviously we need to make sure that if a child is there, that they do apply. Does that answer your question?
Yes, and I fully appreciate you'd actually started to talk about your views on that subject and the answer to the last line of questioning. I wonder if anybody else on the panel wanted to comment about that then, Convener?
Liam Kerr.
Thank you, Convener. Good morning. So I'd like to move on to something that was touched on earlier on, the failure, when there's a situation where someone fails to follow a court order. So Section 16 imposes, or seeks to impose, a new duty on a court to investigate the underlying reasons for that failure, either by the court itself or by a court-appointed child welfare reporter. Now, this committee has received mixed views on that proposal. Some have been supportive and others seem to be saying, look, this actually adds nothing because that duty, that investigation will already be there. So I just seek the panel's views on that. Are you supportive or not necessary?
It's one of the things I think I mentioned before that the families in our services are quite relieved by. Actually, I know that there has been some discussion that this already happens, but anecdotally we're hearing that it's not happening as consistently as it should be. There are often very good reasons for non-compliance with contact orders. Often they actually come down to the child. It's extremely difficult to get a screaming 3-year-old into the car, but it's even more difficult, I imagine, getting a screaming 15-year-old into the car. I think, aside from that, it's extremely distressing, and I think that the ability for the courts to bottom out a little bit more, think a bit more about the reasons behind non-compliance are really welcome. It can be extremely distressing for both sides of the relationship. If a child is being forced to attend contact, it can be distressing for the child, but it also can damage that relationship with both parents. So I think this is something that we really strongly welcome. But for us, I was mentioning before, it kind of we would prefer to be in a position where non-compliance doesn't happen because the court order is satisfactory, the contact arrangements are satisfactory. They allow the kind of flexibility for children to change their mind, or to say that they've been invited to the cinema on a particular day and therefore they don't want to attend contact, but they would prefer to change it to a different day, etc., without having to go through formal proceedings. And I think as well, having the ability for children to respond when a decision is made is really important. But for us, the level of anxiety that we've heard in our services from families who are concerned about not complying with contact arrangements that they feel are unsafe or unsatisfactory, but they feel that they have to comply with, is really significant. So there being an ability to address that and discuss that and talk about, having somebody who is going to sit down and investigate their concerns with contact arrangements is really welcome.
Yeah, we agree that we really welcome this, and again, I think it's something where there's been mixed practice, and anecdotally we've also heard of cases where the reasons behind contact not happening weren't properly investigated. It's also somewhere where the explanation of decisions has a role, in that a child understanding why a contact has been ordered, particularly if they don't particularly want it, may assist. But our biggest concern is that there is a risk that it progresses to a parent who has failed to comply with an order, sanctions being applied without understanding the reasons behind why the order is not happening, whether there are genuine reasons, whether a child is sick that day, that there needs to be a proper understanding of that. And again, we've heard such anecdotal evidence around differing practice that we think it's very useful to have this in the legislation as a reminder to the courts. This needs to be properly investigated when contact orders aren't obeyed, rather than progressing further down a legal route. It needs to go back to understanding what the views of the child are as well.
Yeah, we support this measure. I think, you know, as Chloe said, you would hope that court orders are satisfactory in the first place. And I think the other elements of this bill, you know, properly hearing the voice of the child and taking that into account, properly explaining decisions, read across different legal systems, should go some way to, you know, making sure that an order is satisfactory in the first place and therefore, you know, more complied with.
Thank you. Something very briefly occurs. Are you, if you're in support of either the court doing the investigation or a child welfare reporter, do you think that the extra resource requirements are adequately provided for in the bill? Chloe.
I refer you again to our response to the financial memorandum, where we've been quite clear about the importance of properly resourcing each of these areas. I think that our sense is that if we invest properly in making sure that people are trained and qualified, in making sure that children are able to determine for themselves the best ways that they want to interact with this process, that we will save money eventually, because we will not have repetitive, lengthy court proceedings going on. We will not have vast streams of traumatised children and traumatised adults who aren't able to establish and maintain relationships with the important people in their lives because of decisions made in the courts. So I suspect the answer to your question is that we have called for more resources to be put in place and for more consideration about how things like this will work in practice.
Thank you. Megan Farr, you mentioned sanctions being applied there. Now, the Scottish Government consulted in 2018 on alternative sanctions for non-compliance, but there's nothing specific in the bill. This committee's had evidence that there might be alternative ways to address this, such as alternative dispute resolution, or some have suggested a parenting coordinator. So I just seek the panel's views on sanctions, alternative sanctions and alternatives.
We're concerned that in some instances there have been sanctions which are undoubtedly not in the best interest of a child. There's been cases where a primary caregiver has been imprisoned for a short period of time. The imprisonment of a primary caregiver of a child for a short sentence is always a matter of concern. We think that where sanctions are imposed, that there should be consideration of the best interests of the child when those are imposed. That should be the case when sanctions are applied against primary caregivers in all instances. In respect of alternative dispute resolution or family group decision-making, mediation, other aspects, we think these are important things to consider, and that they may well improve outcomes for children. However, we recognise that many cases that reach the courts do involve domestic abuse, and that in those situations where there's a significant power imbalance, they may not be the right answer, and even if they where in situations which are appropriate, there needs to be a good understanding of aspects like domestic abuse and child development by the professionals. But we do think that a skilled professional facilitator or mediator does have a role to play in these instances.
Thank you. It does. It really does. There's something else buzzing in my mind, which, if you'll forgive me, convener, is very brief. Just because in that answer, Megan Farr, you said many cases that reach the courts involve domestic abuse. Do you have any stats that you can share with the committee on that?
There are a range of stats. There were some that were included in our evidence from our research that we did with Kirstine Mackay. I do have some which I can share, which I can forward to you. My understanding from from speaking to a lot of the academics that are involved in this work is that they're actually fairly consistent in that they're around the 50% or greater figure. It's not an easy area. I think when I was here before Christmas, I mentioned that one of the things we recognise is that conviction rates around domestic abuse are historically quite low. That's why we have a new act that looks at a better understanding of domestic abuse. Maybe the Scottish Women's Aid and Assist could probably have some statistics as well that can help. But certainly when I've been looking at the international evidence, it is fairly consistently around half. That's not unsurprisingly when you consider that the cases that reach the courts are the ones with the highest degree of conflict, simply by their nature. Parents who can agree before they get to court.
Thank you very much.
I should probably point out that Sarah has provided us with a very good report just on some of the statistics, but it's always good to hear if there's any other comments. Liam, sorry, stopped you in the middle.
No, Chloe, I think, was going to...
say that I think it's also worth noting that that hopefully this will change with the new domestic abuse legislation, but we work with a number of women who don't recognise themselves as victims of domestic abuse, or who are encouraged by solicitors, for example, not to report in the civil courts, or who don't feel comfortable or confident or like it's relevant, or who aren't going through civil criminal proceedings. So just a note of caution on the research, because there are probably a number of unreported instances as well.
And that's why that knowledge of domestic abuse, and particularly coercive control, for people involved in alternative dispute resolution and mediation is really important, because that may be the point at which professionals first come into contact with an abuse situation, with, as Chloe says, someone who isn't actually aware that what they're experiencing is domestic abuse.
Thank you.
Okay. Rona.
Thank you. Section 10 of the bill requires local authority to promote personal relations and direct contact between looked after children and their siblings to an appropriate extent. I wonder if we could have your views on that, please, and whether you have any concerns about that section.
We're really pleased to see this here. It's something that the Commissioner's Office and a number of other organisations have been campaigning for some time. Our concerns aren't around the provisions that are in the bill. They're around sort of other people to whom it doesn't extend. So it extends to children currently who are looked after, but not to children who are formally looked after, is my understanding at present. We are a little bit, well, we think it could be strengthened by a better understanding of who children see other siblings. So we're a little bit understanding about discussing types of relationship. Who children understand as their siblings can be quite complex. Families can be quite complex. It can include step-siblings, foster siblings, as well as half-siblings and full siblings. So although we're aware that it exists in other Scottish legislation, we don't think the phrase whether of the half-blood or of the whole blood is particularly helpful. It's not how we understand families these days. I think the inclusion of that potentially places a restriction on who those children. And our other concern around it is around resourcing, is around ensuring that local authorities have adequate resource to facilitate the contact between siblings.
And would you be concerned about suitably skilled people making those decisions, and training and such like?
Yeah, I think that continues to be an issue across all aspects of this bill, and in particular, and Joanna's already touched on this, where the best interests and views of the children concerned, because we're talking about multiple children in terms of siblings, where those don't necessarily align, and how to make that. But in general principle, we're very supportive of a presumption, and presumptions are rebuttable, but of a presumption that it's important to maintain relationships between siblings. Okay. That's something that young people, particularly looked after young people, tell us is important.
I jumped the gun and answered this question earlier, so I'll just say what I said then. Yes, we are supportive of measures to promote sibling contact where that's in the best interest of children, but we're not in favour of a presumption. We have concerns about how parental contact decisions are made, and de facto presumptions aren't helpful there. And I think the same with sibling contact. It has to be on a case-by-case basis, and it has to be a very skilled person who's making the assessment of whether contact is in the best interest of all children and how to resolve situations where it's in the best interest of one child and not in the other. And also, how is sibling contact going to be supported? You know, we've talked about contact centres and concerns about how we support parental contact. There's nothing in the bill, or, you know, it's not really discussed in the policy memo or accompanying documents how sibling contact would be supported within our system, and what skills are required there and what resources are required there. So I think we support the ambition, but we would just urge caution in how it's going to be implemented to make sure that it's in the best interest of all children.
Thank you. Chloe?
Yeah, I think we're similar. We very much support the intentions and would encourage real consideration of resource and training in terms of implementation, and to encourage the committee to explore further with our colleagues in Who Cares and Clan, who've done a lot of work around this. It's not an area that Children First have a lot of expertise, but I know that they've done a lot of work around how it would work.
Thank you.
That concludes our evidence session. Thank you very much. That's been very detailed and also very helpful. We now suspend to allow for a change of witnesses and a 5-minute comfort break. I welcome the witnesses for our second panel this morning, Fiona McMullen, Operations Manager Assist, and Dr Marshall Scott, Chief Executive of Scotland's Women's Aid. And I thank the witnesses for their written submissions, which, as you know, are always very helpful. We move straight to questions, starting with John Finney.
Good morning, panel, and thanks for your contributions. I know you were present throughout, so I'll join some of these questions together, perhaps. And I started off about the children's participation in decision-making and the proposal in the bill to remove the 12+ presumption. So could I have your initial thoughts on that, please, and what you would suggest the new presumption would look like, and whether, as I think a recurring theme of our interest is, whether you feel there's a sufficient infrastructure there at the moment, or the bill proposes something and additional resources. So covering that area, if you could, please.
You want? Yeah. Okay. You're doing the mic, right? Thanks. Yes, thanks for the opportunity to be here and to see you all and to speak about this bill that we feel so strongly about and that children and young people have spoken, eloquently about. In terms of the presumption, I guess our feeling is that I have personal experience of working with people who have gotten provided evidence to sheriffs in contact cases with children as young as 4 years old. I think that the presumption not only is a problem in terms of putting in assumptions that are really not evidence-based about whether you can choose a particular chronological milestone for when children have the capacity to engage with the system or not, but it also, the implication for me then is that their right to participate is abrogated somehow by age. So I think we're definitely in favor of a presumption that children will participate, and that we would want to see the burden be on the courts for explaining why they didn't engage with the children, rather than a presumption of age saying that they should. I agree with the comment, I think, that was passed on from the Law Society or Family Law, not sure which, comment about the fact that solicitors already do assessments, and sometimes we have a case study of a young woman who was represented by a solicitor in the Northeast, who got her own solicitor through our service, and that the process there was that the solicitor had a meeting with the child to try and assess whether the child was capable of instructing her, and made the decision that she did. So the system already works somewhat like that, but it doesn't work with any protections or presumptions for children that they should be involved. So we would like to see that presumption removed, but we'd also like to see a presumption that children will be engaged. In terms of infrastructure, it's a terrible problem. It's a really big problem in the sense that, and I know this is an issue that's woven before the previous panel, but also in all of our submissions, which is that we have a society that's then reflected in our criminal and civil justice systems that is not particularly child's rights competent, and that the infrastructure, the implementation of the bill will only be as good as the understanding of children's rights and domestic abuse in our world is in the professionals who are supposed to be making these decisions. So I would have a clear understanding that in order for any of this to be implemented competently, people will need to be looking at professional competence around children and around understanding the dynamics of domestic abuse.
Yeah, thank you. Just to provide a bit of context, Assist, for those of you that don't know, is a large domestic abuse advocacy project that supports victims and children through the criminal court process. And what we find often, we cover 42% of the population in Scotland, what we find often is the criminal court runs alongside civil court proceedings or is very closely followed. So if we're thinking about domestic abuse, if we're thinking about coercive control, then we're talking about tactics like isolation, exhaustion, degradation, threats. very nuanced and bespoke to the individual families and often involving children and child contact. And what we see is victims and children that can't understand why in one area, if they have court advocacy available, they will be proactively offered that support all the way through that process to risk assess and safety plan, because it's going to be fluid depending on the decisions made by the court. And yet when they come out of that and they go into the civil court, there is nothing. And what I hear victims saying to me is that they find the civil court a more adversarial process than the criminal court, where they actually don't have a lawyer representing them. So they find bar reporters can be adversarial, sheriffs can be adversarial. So in terms of children, getting back to children giving their views, we do that routinely just now. We support child witnesses giving their evidence in court, but with the new offence and the new presumption in favour of non-harassment orders for every child, in terms of domestic abuse, then we are routinely asking children for their views, either directly or through the parent, depending on what our contact is and what's appropriate. And I would echo what Marsha said about children as young as 3 saying, no daddy, I don't want daddy. 14-year-old recently has written a 4-page letter to civil court following criminal proceedings where he was given evidence to say, I don't want contact. Now that boy by default rather than design has been supported by that, because it just so happens we supported him through criminal court. But for many other victims and children, they don't have access to that. So there's something for me, and Marsha and I have spoken about this, about court-based advocacy that is not a postcode lottery for children involved in civil court processes.
Can I just add to that point, which is the infrastructure question really is not only about competence, but it's about availability, and we're certainly aware that, so both Assist and Women's Aid provide children's advocacy services. Ours are not limited by court processes, so people can come through our services who haven't been in a court process. But the reality is that the availability of these services is absolutely inadequate, even in the best resourced communities. And I would say, you know, the West of Scotland has Assist in Glasgow area, certainly, and Edinburgh areas. But when you look at some of our services that exist in the most remote and rural areas in Scotland, the access to the kind of advocacy that should be a human right for every child involved in court processes, especially those who are survivors of domestic abuse, is just not a physical reality. And somebody, somewhere, we hope you, will take that on as a critical element of actually making the law, turning access to justice from something on the paper to something that children really experience.
I totally agree with that. Both services support children through civil court by default almost. Well, certainly for our service, it's by default. It's by someone knowing that they can come and ask us to do that. It's not something that was proactively offered.
Yeah, thank you. The committee's heard frequently about this tension about and I didn't necessarily, between criminal and civil, and I didn't necessarily take it that you're both saying everything's fine in the criminal. No, but better. Yes, indeed. So my question is there a growing gap in provision? Is this bill the vehicle that can address that gap, perhaps by amendment? You know how legislation works. Or are there shortcomings in resources generally? I mean, I'm interested in, I think the term infrastructure has been used by both myself and Dr. Scott.
I mean, I think the answer, sadly, is we need all of the above. I don't think this bill in itself, even when crafted absolutely perfectly, will solve the gap between criminal and civil. And I have to say, I'm a bit less optimistic about what's happening in criminal courts also, because I think we have not, as a country, really adjusted well to the new provisions of the Domestic Abuse Act that now have a criminal element around the child aggravator in them, and figured out what that means for children and what their role should be in the courts. As some of you may remember, we, along with a number of the children's organizations, argued in the Domestic Abuse Act in the development of the Domestic Abuse Act, that children should be considered as co-victims, because our concerns were that when, exactly what Fiona was describing, when cases went from criminal to civil court, somebody who'd been convicted of abusing, being an abuser in a family was then seen as a good enough parent. So I think the gap is potentially going to get wider, but it is as wide as it can be at the moment anyway. I think that adequate advocacy services will be the best first action we can take to try and address the problems caused by that gap. I still think we have there are things that should happen around how we describe children as victims in terms of domestic abuse. And I don't think the aggravator, we have no evidence, at least at this point, that the aggravator is working adequately to do that. Yeah.
Okay, thank you very much, Nate.
Thank you, Rona.
Thank you. Just going back to the age presumption question, and I suspect you'll be able to answer this quite briefly, about the retention of the 12 plus for being mature enough to instruct a solicitor. What do you think about that? Do you think it's part of a? Do you think it's good to be kept in the bill, or is it part of a wider review?
I think we've all just said that in our view and in the view of the evidence, really, there is really no benefit of identifying an age, and that the presumption should be that children should have a voice unless you can demonstrate that they can't.
Okay.
And I suppose the only thing to add to that is it's not always the solicitor that's going to best represent the child's views in a court process.
Mm-hmm. Great, thank you. And my other question would be, in respect of children giving their views, should there be a non-exhaustive list of ways that children can do that? And should a child have a say in which method is used in their individual case?
You go, girl.
Tagging. I don't agree with a list. I think it becomes, as others have said before me, prescriptive, so I'll keep that brief. I think there are really creative ways that take skilled professionals in terms of engaging with children, communicating with children, age and stage appropriate, that can absolutely be used to give views.
I might disagree a little bit, which is just that I think in the domestic abuse bill, one of the things that has worked really well in that bill is the really extensive guidance notes that state quite clearly these are some of the effects of abuse, this is what abuse can look like, but they're not exhaustive, and I think it helps inform people's understanding.
Whether it's in the bill or not, whether it's guidance notes.
So I think it can be a signal that says that, F9's not going to do it. And that there need to be options. But the core principle needs to be the outcome, which is that we have done everything that we can do to honor children's human rights and to have input into decisions that affect their lives. And whether that's through a video or a painting, or as this 4-year-old did, a picture around the rooms in my house and where I feel safe, then, whatever it is that works is the thing that we should do.
And do you think the bill needs to be a bit stronger on that point and maybe emphasise that more specifically on the face of the bill?
I think, and it's a bit like what Megan said in the last session, that a number of things in the bill are not framed from a children's rights perspective. And if we could put that up front and in bold and say, this is the outcome that we're trying to get to, and here are some of the many ways, just like you said, there's many creative and well-evidenced mechanisms, then that's the proof that we're looking for, that people have engaged in those.
Yeah.
And just to add, it's about how we also assess through that whole process how risk is manifesting and safety is being managed in giving those views. Some children will be absolutely terrified to give their views. They don't know where that's been shared. They don't know the consequences for giving them. So for me, this is no different to a criminal court process in terms of managing risk and safety all the way through it and beyond, and potentially for a longer period of time, given that criminal proceedings can be incidental, very quick, and result in one appearance. If we think about special measures for victims in a civil court, we're talking about multiple appearances, but there should be an absolute emphasis on risk and safety.
And can I just add to that? In our experience in talking to children and young people and what they have told us about what they need to give good evidence and to express what they need and want, it's a process, it's not an event. It's not, well, we used the right form and the child didn't want to speak, so therefore the child maybe doesn't want to be involved. And we have many, many cases, and I could, talk about the need for children to have a relationship with a trusted advocate or supporter in order to give good evidence, just like any evidence process, but that it needs to be, that we need to set it up so that it is, again, clearly defined as a process, and that if the process doesn't deliver safety and well-being for children, that they have redress, that they have a way to ask again for it to be reviewed.
Okay, thank you.
Bill.
Thank you very much, Convener. Thank you for the interesting conversation so far. Can I ask about explaining decisions to children, as in section 15 in the bill? Now, it says in section 15 that exceptions to the new duty pardon me, include where a child is not capable of understanding the explanation or is not in the best interest of the child, and the Sheriff's Association thinks it's unworkable in practice due to the burden it places on the judiciary, whereas others, such as the Children's Commissioner, are concerned about these caveats being introduced because they believe that it's not in the child's best interests in many occasions that these caveats should be used, and therefore there will have to be someone in whom the child has confidence and trust in order to be able to actually explain these things only if necessary. Are you concerned one way or the other about this?
Assist would be concerned at that caveat, that became almost the norm, that didn't need to be explained. We do that within criminal processes just now. We absolutely give the child the court outcome, debrief after giving their evidence, which isn't dissimilar to giving your views. There's a consequence from that, a consequence around risk and safety that is then explored. And also a lot of, and again, this would be built up with someone you've got a trusting relationship with, there's also something about believing and validating what the child's been through and done, so that if the outcome isn't necessarily what the child wants, that there is potentially redress around that, but there's also an acknowledgement of how well they've done to be involved in that process, and again an emphasis on the safety of that outcome of the decision making.
Right, okay. And Marcia?
Yeah, I just agree with what Megan said in the previous session. I think the circumstances and the number of cases in which it wouldn't be appropriate to share the decisions of the court with a child or young person are very rare and tiny, and that those are likely to be, addressed on a case-by-case basis, obviously, and always involving a trusted supporter is, involving a trusted supporter is always one of the alternatives you would want. But I can't imagine that we would want to put in a bill a get-out clause like that, which is what it seems to me.
And does that, what you both said there, does that counter the concerns of the judiciary in terms of the burden placed on them, on their resources, because it's already being addressed in other circumstances, and that you wouldn't really have that concern, and it may actually be that this is just something that's being put in place because they don't really want to actually have to deal with it or something,
It might depend on the outcome.
Right.
I can imagine I've been involved in supporting children years and years ago where the outcome of the Procurator Fiscal in a criminal case was to not go ahead with their charges, was to drop their charges and go ahead with the mother's charges. That was a really poor outcome for that child, and that child absolutely wanted to speak to the Procurator Fiscal about that, as opposed to myself as an advocacy worker.
Right.
So I can still see times where it might be appropriate for the child to have to have information given to them by someone other than an advocacy worker, a supporter, child welfare reporter, that they might prefer it to come from the judiciary. But I wouldn't see that as being something that needed to happen all the time.
So it's always what's in the child's best interest, and that can be variable on certain occasions, actually. Yeah.
I guess my feeling is that, well, I have some sympathy for the burdens on the judiciary. I guess my first thought is that should be solved in other ways other than minimizing the rights of children to hear the outcomes.
Sure. Thank you very much for that. Thank you.
Liam McCarthy.
Thanks very much. Good morning still. You will have heard the exchange earlier on around confidentiality of information and the balance, I suppose, that Professor Sutherland was talking about in an earlier evidence session between ECHR rights to a fair trial for adults and the rights to privacy and I suppose best interests of the child in terms of being able to give their best evidence, have their views heard, but the sensitivities that may surround some of that information. How would you respond in terms of how the bill should strike that balance? Do you believe there should be a specific provision in relation to confidentiality, and how would that be framed?
I think we support Children First's call for an amendment around confidentiality. We've been aware for a very long time about the difficulties of being able to provide support and become a trusted source when the possibility might be that information that a woman or a child has shared with you will be used against them in a court. I can't imagine anything more soul-destroying, both for the child or for the service worker, I have to say, to see work that they had done under sometimes incredibly difficult circumstances to help children become more confident that the system was there to protect them and to use it, and then to have it turned around on them in the way that it can be done and has been done by courts in Scotland. So I guess my concerns are obviously that it's always proportional, but that we do what it says on the tin, that children's interests are paramount. And when there are other people's interests involved in the case, obviously those are going to have to be weighed, but we need always to act on the outcome that the well-being and interests of children is paramount.
I don't have a lot to add to that. I would echo what Marcia said. I suppose I'm always going to take it back to how is this managed then, and having a trusted support worker through that process would undoubtedly help to manage that, because it's also about children's expectations being managed around when we can't address risk unless we share some of the information, then we will absolutely have to. There's transparency there, there's consents there, etc. to be considered, and that's provided more robustly if it's a consistent person overseeing that process.
So that it'd be framed in a way that doesn't, in a sense, move away from the fact that some sensitive information, some difficult information will have to be shared in the interests of providing clarity to the court. But actually the management of those expectations needs to be carefully handled throughout the process, and any information that's shared is proportionate and directly relevant to that.
I mean, I think we have some existing practice that's pretty good in that area. I know I was speaking to a sheriff recently who was saying that she took views from children, and she was very careful to make sure that didn't get then replicated in the court proceedings unless there was a child protection question that needed to be answered using that information. And I think we all have worked in an environment where child protection trumps pretty much any promise of confidentiality that we can give. And that's not a new environment for us all. So I do think the reality is that we can express that to children and then actually hold up their rights in that situation. And that's not a new concept for the system, really.
So are the problems arising at the moment, in a sense, because it's easier just to say all of that file, all of that information needs to be made available, rather than a lack of understanding that there will be some information there that is directly relevant and other information that's not directly relevant.
As Marcia says, we do that just now.
Yeah.
We are regularly asked for information to go into civil court proceedings from bar reporters, from the victim's own lawyer, and we make a decision about what's proportionate and relevant to share from that. So, for example, it might be the themes of risk rather than the detailed, intimate details about that. So it's about what's required. So we do that just now.
Okay. Thanks.
I know you were both in when we had the previous panel were here, and we looked at Section 1 and Section 12 and the statutory factors that are intended to guide the court when making a decision about the child's welfare in any individual case. I wonder if we could have your views on this idea of approving a checklist of factors in principle, and also the view that was brought up by Parenting Scotland that this was a missed opportunity to have a comprehensive list of factors that might include certain groups of people.
As you'll know from our response, we're quite concerned at the existence of a checklist, and we think that it's pretty random what was put on it, I guess I would say. I mean, you know, there's some things that aren't on there that we would want to see as an absolute principle, like listening to the views of the child, and the participation of others in a child's life, or even of both parents, when actually the evidence says that often that's not in the interests of children, is problematic. I think the intent was good, which is the intent is to remind the courts that these are the things that they should be considering in making any decisions. And I think that needs to be expressed really strongly in all throughout the bill, rather than providing a sort of shorthand, way to avoid having to actually understand the principles, but you can just do the checklist. So if there were a checklist, we would want to see it much more rigorously examined, and that it reflect the principles of the paramount interest of the child, and the well-being of the child. I couldn't defend the existing checklist. I think it could only possibly lead to helping support decisions that are really not in the evidence from the case. So in terms of the shared parenting consultation response, I think I have some strong concerns that that what we're really seeing is trying to protect the rights of parents rather than of children.
Fiona?
I'm not going to labour that point, but I agree that it's what we've found just now, and what victims regularly tell us just now, is that the rights of the perpetrator, often the father in these circumstances, absolutely outweigh the safety of the child and the voice of the child. And we wouldn't want anything that could further that.
Okay, so I think the point's been strongly made. You did mention your submission. I think there should be an update, Marcia, of the domestic abuse to include coercive behaviour. Is that something that should be looked at stage 2?
I'm sorry, could you...
Domestic abuse, an update of the definition to include coercive behaviour, something to be looked at stage 2, perhaps?
We were quite concerned that the language in the Children's Scotland Bill didn't seem to reflect the language of the Domestic Abuse Scotland Bill. And in particular, the complete absence of a discussion of coercive control and the impact that it has on children, which we discussed lots during the debate around the Domestic Abuse Bill. So, and I think certainly I exist in a bubble. It's possible that that bubble is shared by the people in this room, that everybody understands now, because of the debates around the Domestic Abuse Bill, the mechanisms, dynamics, and impact of coercive control. But I think that would be a mistake to assume that, and I would be very concerned that this bill not demonstrate policy coherence across with the new Domestic Abuse Bill. And also, I think, the reasons that children and women often are not seeking services, reporting to the police, engaging with our systems, is because their fear and their harm has been minimized for so many years when it wasn't a physical assault. And I think we need to understand that those are the same people that are going to be coming into our civil courts, and many of whom domestic abuse there may not have been a formal criminal case. And as was mentioned in the last panel, we hear stories all the time from women about lawyers telling them not to talk about the domestic abuse for a variety of reasons. And I think that we need to not be naive that people are going to understand coercive control, talk about it from the beginning, and that the court's going to then reflect it appropriately.
Fiona.
Yeah, I echo that. I think anything that makes our systems and our processes in each court more compatible and more complementary of each other. We've already heard that there's vast differences in terms of response, so anything that mitigates that would be helpful.
Yeah, I think that message has been held loud and clear this morning. Shona.
Hi there. So a question on, firstly, the child welfare reporters and curators. You'll be aware that the proposal to regulate those, and as I understand, I think you're supportive of that. It would be helpful just to hear a little bit more about the features of any regulatory regime that you think is necessary, like qualifications and training and so on, and also similarly with child contact centres, whether you believe there should be statutory regulation of child contact centres, and again what the key features of any regulatory regime should be.
I'll start with contact centres. I mean, and this comes from talking to victims over the years. Well, one victim recently said to me that using the contact centre wasn't much different, not to be flippant, than handing a child over in McDonald's. She would expect the same intervention should she be assaulted, but that was as much as they were going to notice in the contact centre. They weren't going to notice if secrets were being shared, if photographs were being taken, if the parent was being undermined or anything like that was going on. They weren't going to notice the dynamics of abuse. So that, to me, speaks about training. It speaks about regulation, it speaks about complaints procedures, but also thinking about using contact centre in the first place and how we use them and we quickly progress. Because if we're talking about domestic abuse and coercive control, we're talking about perpetrators. They're very clever and they will go to contact centres and they will look the part and they will do the part and they will turn up, and it will move very, very quickly to unregulated contact that's not supervised anymore. So I think we have to consider our use of contact centres in terms of, again, reviewing risk and safety through this whole process. Also hear victims talking about paying to go to contact centres, either paying to travel to them or paying for sessions. I've worked with a victim who what she paid for the contact centre getting there outweighed the £6 maintenance a week she got from her ex-partner. So there's something fundamentally wrong there, that in managing contact, victims who will experience significant financial control as part of their abuse are being further financially abused by the processes that we put in place. Don't know if you want to add to that.
Of course. In terms of child welfare reporters, I can't say it strongly enough, I suppose, how welcome the regulation of that and the required training would be. We hear stories every week. I had one a week before Christmas about a woman being told by a bar reporter that she shouldn't take too seriously the threat to kill her, and that because people say things in the heat of the moment. I think these are attitudes that are not uncommon in our communities, and we really have to take our responsibility for making sure that the people who are dealing with the most vulnerable and at-risk people in our society have the tools that they need to do that. So I really welcome it. It needs to be good training. It needs to be looked at with an implementation lens, because I think we have a tendency to say, we have had these discussions with the Judicial Studies Institute around the training of sheriffs and judges on the new domestic abuse bill, which is that, we have a tendency to say, we've checked the box because people have attended a training, and we might even do a pre and post to make sure that they understand what was said in the training. But what we don't then do is put in the infrastructure needed to make sure that they use the training. And I think with bar reporters and court reporters, child welfare reporters, we must take a robust approach to that, and it'll be so welcome. In terms of contact centers, and I've said this when there were discussions with the Petitions Committee around the contact center case that was brought to the Public Petitions Committee. If what we say is that the first principle of contact is that it cannot be ordered and should not be ordered unless we are absolutely clear that it is safe and safe for both mother and child, or victim and children, other victims who are children, and in the best interests of the child. Why do we need an industry of contact centers to then protect children if we have any concerns about their safety? Why are we allowing contact? So I think if contact is going to be safe, it can happen in a lot of places that are probably more conducive to children's health and well-being and connecting them and their parents with community services. So family centers, we have a network of family centers in Scotland that provide lots of services for children and parents, and I don't see why family centers and community centers wouldn't be also appropriate places for contact to happen. If we're going to have contact centers, and obviously I come at this from the perspective of domestic abuse, maybe there are other functions and circumstances in which we need to have contact centers, then they need to be designed and delivered with those outcomes in mind. But in terms of the issues around domestic abuse, as far as I'm concerned, there are we have heard so few stories about contact centers actually increasing the safety. And in fact, what we hear all the time are stories about children, being in contact centers. I had a case where we had a children's worker who approached a contact center when a very dangerous perpetrator was being released from prison. Lots of, conviction, evidence all over the place about it, and that contact had been ordered in the contact center, went to the contact center and said, I think we should work together around this. We've been supporting the child, actually 3 children, the children, and can we make some safety plans and do that? And the response from the contact center was, listen, there's 2 sides to every story, I think we must not underestimate the harm that happens in contact centers where services are inappropriate and the people who are providing them with the best will in the world are unable to provide safety and, in fact, therefore provide danger.
Can I just go back to bar reporters just for a second? And I'm just thinking over the years that I've been at Assist, 15 years, I've heard fairly routinely victims talk about feeling like bar reporters are coming from a position of disbelief, and that they have to convince someone that this is not tit for tat, which kind of follows on from some of the issues around contact centre, that this isn't just a fight for the need to win residency, that there is domestic abuse and coercive control at the heart of that. So this is meant to be the professional that has more understanding than perhaps your own lawyer or the sheriff, and is going to convey that to the sheriff, and actually is less. I've also worked with excellent bar reporters, and bar reporters that have been honest enough to say after an hour looking at one case have said, I've missed other cases because I haven't noticed these risk indicators, I haven't noticed this has been going on. So absolutely echo what was said this morning about the quality of bar reporters, child welfare reporters, and looking outside the legal profession for that, and echoing that I don't believe that they come with the same, as I would suppose assist in women's aid at times in court as well, don't come with the same credibility, and that needs to shift. There needs to be an acknowledgement of the experience and the skill and the professional judgment of other professionals that might be involved in that work.
I really need to echo that. I mean, the vast majority of children's supporters and advocates that exist in Scotland work for one of our two agencies for children experiencing domestic abuse. And the fact that it is very, very difficult to get courts to listen to the advice from these professionals is a huge waste and of what are public pounds most of the time, but also of the trust that children have finally built up in a system that will listen to them.
Thanks for that. Again, if there's some further examples or more detail you want to share with the committee, you've touched on some examples, that would be very helpful if you want to follow that up in writing.
To do that.
Yeah, it's always very worthwhile. It kind of brings it alive. Could we have Fulton next?
Thanks, Convener, and good afternoon, panel. Thanks very much. I want just like the same as the previous panel. That I know you were in for. I wanted to ask about the vulnerable witnesses, and particularly the first question around about sections 4 to 6 of the bill. Just to get your overall views on that, and I suppose just to combine a further question, do you think that the protections for vulnerable individuals should be the same across civil and criminal proceedings? And if so, if you agree with the sections 4 to 6, which I think you do from the submissions, do you believe that achieves that goal?
I absolutely believe that it should be the same across both processes. Victims just now are incredulous that 1 week they're in a criminal court, given their evidence in a brand new site in Glasgow, especially if it's involving children, where they don't come into any contact with the perpetrator, or in the court they have screens, they have a safe entry and exit, and then the next week they're sitting across a table from their abuser for multiple appearances, and it's really distressing to victims. I've been in here long enough to remember when we didn't have automatic measures for children, let alone adults, and how that has really changed some of the trauma that is associated for children and adults in terms of going to court. I would be suggesting something not dissimilar to the criminal court, where they have a default, so that if they don't know what is required, that they have a default position at the minimum that should be there and available, which in criminal court you'll know as screens and a supporter. And then, because that's easy to take away, that's easy to not have, rather than, again, it's about how we're going to be in contact with people, how we're going to get their views about what's required at court as well. That all needs to be considered in the process of that.
I agree. The only thing I would add is, there's some really good work happening in Scotland around the Bairnshuis and, the development of responses to children in our system. And I think the principles of that should be integrated in the way we protect children in court proceedings.
I think that the difficulty here will be, how do we determine that someone requires it? Because in criminal court we have a domestic incident that's happened, and we need to appreciate that in civil court we might not have those incidents. It might be reports from the victim rather than convictions to go on, so we need to consider that. My position would be, if someone wants special measures, there's a reason for that. And very few people would ask for them if they don't want them. In fact, we have some victims who say, no, I need my abuser to know that I can actually do this without those special measures. So it will be very much on a case-by-case basis.
Absolutely. And I would just support that, given the fact that we have ample evidence over many years in many countries that many victims of domestic abuse never report to the police, and so we don't have a criminal case, that we need to include in the bill language that would allow allegations of domestic abuse or abuse generally to define this rather than a conviction or a criminal case.
We could call them reports, because even allegations, sometimes I think when we hear that in civil
Exactly.
court, suggests a disbelief. These are reports of abuse.
Exactly, yeah, like there's...
We could go on.
And would you agree with the previous panel in terms of would you support an extension of sections 46 to the children's hearings themselves?
To be fair, ASSIST doesn't have a huge amount of involvement in children's hearings. From what I heard earlier, what was said absolutely made sense to me. But it's not something that we're routinely involved in. We might have young victims at children's hearings rather than a number of children going through that process. I don't know if you want to comment further.
Just a bit of a follow-up from the previous panel, which I thought was pretty clear about children's hearings. But I would say that we've been working with the children's hearing system to provide some training. And there's now rolling out the service around providing advocacy for children. And it comes back, I suppose, to this notion that somehow the children who are already being supported by a supporter or an advocate should then have to switch to somebody else who's a bar reporter or somebody else with a different credential. And I think that the children's hearing system is moving in the right direction in terms of making sure that children have advocates, but doing it in a way that sort of puts at the lowest level of support the support that's most appropriate, and then what children and young people have told us from the very beginning, whether it's in Power Up, Power Down, or in our existing young experts group, that the presence of an adult with trusted relationship is the most important thing for justice from their perspective.
And just one final question, if that's okay, Convener. The previous panel asked about the Section 7 provision in the bill, and I know Dr Scott, the Women's Aid have been critical of this provision. I wonder if you wanted to take the opportunity to put some of those thoughts on the record today. I'm going to plead holiday brain. I'm looking for Section 7, but adrenaline will tell me that I won't find it easily. So do you want to... So Section 7 of the bill would allow the Sheriff Court for the first time to order use of special measures in court hearings where formal evidence is not being taken, including child welfare hearings. Unlike Sections 4 to 6, nobody is deemed vulnerable in this context. An individual's vulnerability must be established before the court in each case.
I think what we want to do is go on record that that everything we should do, whether it's in a hearing system or in a civil court hearing or even in a criminal court, is that we think about it both from the perspective of what's in the interest of the child's well-being as well as good evidence. And happily, the answers to both of those things are often the same, which is a default position assumption about protections, such as the ones that are in place for vulnerable witnesses. I will say that our experience is that access to special measures is really good in some places and really not so good in others. And courts will be less than consistent about making sure that they're available. I think the move to do take evidence from children off-site, remotely, and video is a great place for us to begin to think about how we could actually provide protection rather than, I mean, a screen and a supporter is an obvious, easy answer, but it probably doesn't deliver the outcome we all want.
Okay, thank you.
Thank you. Liam Arthur, very brief supplementary. Liam.
Yeah, sorry, I appreciate there's issues around the management of risk. I was slightly taken by the suggestion there that where there's not even an allegation of domestic abuse, but simply a report of domestic abuse, that this has the potential to I think, provide potentially incentives for individuals to respond accordingly in marital or relationship breakdowns where emotions are running high. Is setting a threshold of a simple report of domestic abuse a sensible approach to be taken?
Well, I think it's evidence, and I think it needs to be taken on board as a signal that that there is fear involved and coercion potentially, and that it's only sensible that the processes that fall out of that once that, and I agree, report, not allegation, is a good word, is said is in order to, you know, make robust decisions that all precautions can be put in place. I mean, I think there are few other situations in which somebody would say they were afraid of somebody in a system that we wouldn't respond appropriately to that, instead of just minimizing it and saying that this is a you know, an allegation that might be self-serving. So I think the court's able to understand those if they ask the right questions.
Liam Kerr.
Thank you, Convener. Good morning. Basically the same questions that I put to the earlier panel. They're looking at the section 16 of the bill, which is about when someone fails to follow a court order. Section 16 would impose a new duty on the court to investigate the underlying reason for that. So I just seek the panel's views on whether that's a good section, or perhaps in the alternative, does it really add anything?
I think we've seen stories recently in the press of non-compliance and the consequences for victims who are afraid. So for me, it's about what is the non-compliance about? Is it about safety? Who's determining what's the non-compliance about? That needs to be someone that's skilled and understands the dynamics of abuse. It's a really tricky one, because non-compliance can be used. It can be used by perpetrators as well. It can be used by abusers to change arrangements to make sure that the victim's further isolated because they can't go out, because they were only going to take one of the children on this occasion. So non-compliance can mean a number of things. I would be really horrified to think of a victim of domestic abuse who is in fear for her or his life and the safety of their children to be to face extreme consequences for non-compliance.
I think we have so much evidence that there are complex stories underneath compliance issues, and that our system has not, the power imbalance between a sheriff or a judge and a victim of domestic abuse who perceives that she has a choice, and I have so many of these messages in my inbox, I can't tell you. Her choice is between protecting her child and breaking the law. So the reality absolutely is that won't always be the case, and I'm sure there are many good explanations for, you know, things that are less defensible around non-compliance. But until we have some evidence that says our system's working the way it's supposed to around child contact, especially in the context of domestic abuse, we have to put some safeguards in. And I think assuming that a contact order was the right thing and that lack of compliance is the wrong thing is not useful in this situation.
Which boils down to, you believe that Section 16 is a very good thing, then that this comes in. Grant, so the second part of that, we looked earlier on at sanctions. And in circumstances of breach, what is your view on sanctions, alternative sanctions that were consulted on but haven't made an appearance here, and some suggestions such as ADR, for example?
Echo what the previous panel would say, which is in the context of domestic abuse where there's an inbuilt power imbalance, mediation is really not a good idea. I will say that we were involved in a panel with officials some years ago. This might be the only time that Families Need Fathers and Scottish Women's Aid agreed about something, which was that we don't think that that prison sentences are a particularly good response to non-compliance for contact orders. We do think that alternatives need to be in place, but the most important intervention we can do at this point is for there to be a good exploration of why compliance is not happening.
And going back even further, as was said earlier, if we put appropriate contact in place, hopefully there's less room for that non-compliance.
Thank you very much.
That concludes our questions. Can I thank you both very much for attending today, for giving very worthwhile evidence. We now move on to agenda item 2, which is consideration of a negative instrument, the Firefighters Pension and Compensation Amendment Scotland Order 2019, SSI 2019/382. I refer members to paper 4, which is a note by the clerk. The committee previously considered this instrument at its meeting on 3rd December 2019 and agreed to write to the Minister for Community Safety. The Minister's response is attached in Annex 4. Was it the Community Safety Minister that actually responded? Digital economy. Yeah. She actually passed it on to Kate Forbes. Do members have any comments on that Annex report, letter? No. No comments? In that case, then is the committee agreed that it does not wish to make any recommendations in relation to the instrument? Agreed. Okay, thank you. That concludes today's public meeting, the part of the in public. Our next meeting will be on Tuesday, 14th of January, when we'll continue our evidence taking on the Children's Scotland Bill, and we now move into private session.